All right, it looks like we've crossed into the magical 11 a.m. hour. Good morning, everybody out there. Tracy and I didn't discuss whether I would be doing the intro or not, so I'm just sort of grabbing the wheel and going.
Good.
But
that was my plan.
All right, good. Well, folks, thanks so much for joining us. It is Tuesday, July 20th, and we appreciate you being here for our ongoing webinar series where we help you navigate all the ins and outs of running a business, paying your people, treating them well, and all the good stuff that goes into that. And certainly all the legislative changes that have been a part of our lives over the last 15 or 16 months. Today, we're going to dive into the Virginia Overtime Wage Act. So if you are a client of ours or you're joining us from the wider community and you're not operating in Virginia, there's going to be some valuable information, but not very specific information for you today. But if you're in Virginia, buckle up, this one's for you. Before we dive into this topic, just a couple housekeeping items. We will do our best to answer questions that you have. If you could submit those through the Q&A that you see at the bottom of your screen and avoid the chat, we would appreciate it. The Q&A plays nicely with our recording of this webinar, and the chat disappears at the end. We do try to preserve these so that folks can review them on their own time later. We make every effort to host these on our website. That's dominionpayroll.com, and we'll have this up by the end of business today. But you can always go to dominionpayroll.com and hit that COVID-19 resource button at the top of the page, and you'll be able to review past webinars where we share the deck, the recording, questions that are answered. So a lot of resources there. Additionally, if you have questions that we aren't able to answer through the course of this webinar today, or something pops into your head in the dark hours of the night and you just have to have it answered, shoot us a note to questions@dominionpayroll.com, and we will do our best to get you a timely response there. That being said, I am joined by my colleagues today. I've got Tracy Clark, who's going to be guiding this presentation, and then Nick Summer, a new addition to our exciting webinar team. Nick joins us from the tax department. How are you guys doing this morning?
Doing pretty good. Busy.
I'm doing well as well.
Good. Well, with all that being said, I'm going to pass the mic over to you, Tracy, and let you take the reins on this thing.
All right. Thank you so much. Yes. So we are going to talk about the Virginia Overtime Wage Act. But before that, I'm going to do a little of the Fair Labor Standards Act background. So I wanted to really understand the FLSA prior to talking about the VOWA, because I really needed to understand the differences, because I think that's what we're all here for, is trying to figure out how does this affect me differently than it did before July 1st. So let's talk a little bit about the FLSA. So the Fair Labor Standards Act, FLSA, establishes the minimum wage, the overtime pay and the calculation thereof, record keeping and youth employment standards affecting employees in the private sector and in federal, state, and local governments. So covered non-exempt workers are entitled to a minimum wage of not less than $7.25 per hour, and that was effective July 24th, 2009. An overtime pay at a rate of not less than 1 1/2 times the regular rate of pay is required after 40 hours of work in a work week. Now, obviously, we don't pay $7.25 in the state of Virginia, and there's lots of other states that have different amounts. So I just went on and looked more into that. The FLSA minimum wage, the federal minimum wage, is $7.25 per hour, but many states have their own minimum wage laws. And in that case, where an employee is a subject to both the state and the federal, the employee is entitled to that higher minimum wage. So for us in Virginia, the higher amount is $9.50. That was increased to that amount beginning May 1st, 2021. It's going to increase again to $11 on January 1st, 2022, and then to $12 on January 1 of 2023. So it is different in a lot of states, and I wanted to draw attention to what it is in our own state of Virginia. Okay, so overtime under FLSA, covered non-exempt employees must receive overtime pay for hours worked over 40 per work week at a rate that's not less than 1.5 times the regular rate of pay. And that regular rate of pay is the employee's hourly rate plus other non-overtime wages paid or allocated to that work week. So that would be like commissions and bonuses and or hazard pay. So any of those things are also added in to that hourly rate. You can take away any applicable federal exclusions, and that would be like gifts, reimbursements for travel expenses, holiday pay, PTO, sick leave, and other paid time off. You divide that by the total number of hours worked in that week, and that's going to give you the regular rate of pay. Some states have overtime laws, and that's where we fall under now. In cases where an employee is subject to both the state and federal overtime laws, the employee is entitled to overtime according to the higher standard. Just like they're entitled to the higher minimum wage for that state, they're also entitled to the higher overtime for their state. Okay. So overtime under the FLSA, and the reason that I'm going over this is because this is how it was prior to the 1st of July. So we didn't have our own overtime laws, and this is all new for us. So I'm just going to talk about how it used to be and then how it's changed. So an employer may opt to pay a non-exempt employee a salary based instead of an hourly wage, and such an arrangement is typically advantageous for the employee. Because employers are not relieved of the obligation to track hours worked for non-exempt employees, regardless if they are hourly or they're paid a salary, you still have to track their hours because you're going to have to pay overtime to both of them. It's that non-exempt status that is the caveat here, that you have to collect the time that they worked. In some environments where overtime is very rare and timekeeping is very simple, a salary may be administratively easier. However, employers should not make the false assumption that paying a salary means an employee does not have to keep records of actual hours worked. So you have to keep track of what they actually work, whether they are salary or hourly, if they are a non-exempt status. Okay, so for covered non-exempt salaried employees, there's an additional way to calculate the overtime pay they're owed. It's something called the fluctuating work week method. So non-exempt salaried employees receive a set weekly salary no matter how many hours they work, plus additional overtime pay when they work more than 40 hours in one work week. In other words, the employee's weekly salary does not change whether the employee works 30 hours, 40 hours, or more. In weeks where the employee works more than 40 hours, the employee receives additional overtime pay for each hour of work over 40. So under the fluctuating work week method, overtime pay is based on the average hourly rate produced by dividing the employee's fixed salary and any other non-excludable additional pay by the number of hours actually worked in a specific work week. The average hourly rate will change from week to week depending on how many hours the employee actually worked. The employee then receives at least an additional 0.5 times or additional half time that rate for each hour worked beyond 40 in the work week. So I have a little math for you there, just to show that. So here I have an employee that's non-exempt and they have a salary of $1,000 per week. If they worked 50 hours in that week, they would have a regular rate of $20 per hour. So it's 1,000 divided by that 50, which would equal 20 for their regular rate of pay. Now, if they only worked 45 that week, it would be 1,000 divided by 45. If they worked 52, 1,000 divided by 52. So it fluctuates. At that point, once you know their regular rate of pay, their overtime rate is going to be the regular rate of pay. In this case, it's 20 times 1.5, and that gives you $30 an hour. So they would get their straight time earnings of $1,000. That's their weekly amount, plus their overtime earnings, however many hours that they worked times their overtime rate. That would be 10 in this case times 30 for a value of 300, and their total earnings would be $1,300 in that case. So that's how it works under FLSA. Beginning on 7/1/2021, Virginia employers will be subject to new state overtime pay requirements. Previously, Virginia had been content to rely on the overtime pay requirements of the Federal Fair Labor Standards Act. So that was previous. They went through and they've changed this. Now, for your hourly employees that have an hourly rate, it's not really changing how you do that. This is really affects your non-exempt salaried employees, and I'm going to go over that. But these are the three ways that VOWA departs from the FLSA. So changes the calculation of regular rate of pay for non-exempt salaried employees, and I'm going to walk through that slowly so you can see how that works now. It gives employees 3 years to bring lawsuits from the date of the violation, regardless of whether the violation was willful. And then lastly, omitting good faith defenses for employers and providing for potential triple damages and interest. All right, so let's look at this regular rate of pay calculation under VOWA. And then remember, this is for non-exempt salaried employees. So the way you have to figure it out now is it's going to be the employee's total weekly compensation divided by 40 hours, regardless of how many hours the employee actually worked that week. So previously, it was all hours that they actually worked. You were taking that compensation, dividing it by 50, dividing it by 45, 52, whatever the employee actually worked. Now it's set 40 hours. So let's look at our previous example with my employee that made $1,000 per week and worked 50 hours that week. So now what you're going to have to do is you're going to take that $1,000, divide it by 40, and that's going to be $25 for regular rate of pay. Multiply that by 1.5, and $37.50 is going to be his overtime rate. So now he gets the straight time earnings of $1,000 for that week, but the overtime earnings is now going to be $375 because it's going to be the 10 hours that he worked above 40 times that new $37.50. And the total earnings is going to be $1,375 as opposed to the $1,300 under FLSA. So it's definitely going to make it could make a big difference depending on how many hours these non-exempt salaried employees work. Okay, statute of limitations. So under FLSA, suits must be filed within 2 years or within 3 years if the employee can prove that the violation was willful. Under VOWA, all employees have 3 years to file suit regardless of whether or not the violation was willful. So employees can recover back wages for that 3-year period. FSLA and VOWA overtime claims. So these are the kind of situations that employers can find themselves in. Employers may mistakenly classify an employee as exempt from the FLSA overtime requirements, and these misclassified exempt employees who are really non-exempt often worked regular on-the-clock hours in excess of the FSLA overtime thresholds, as well as compensatable off-the-clock hours. So be careful about these misclassified employees. Make sure that if they are exempt salary, they truly are qualifying as an exempt salary and not non-exempt salary. Employers may fail to identify, record, or compensate off-the-clock hours spent by employees performing compensatable job-related activities. For example, employees may perform a variety of potentially compensatable job-related activities during their off-the-clock time, such as taking work home, receiving job-related phone calls at home, working through lunch, working before or after regular shifts, taking care of work-related equipment. So again, be careful about the time that employees are actually working. Employers may fail to include wage augments such as longevity pay when calculating an employee's overtime rate. Available remedies. As with FSLA, VOWA also provides for the recovery of lost wages plus liquidated damages, but has no good faith exception for employers. If the court determines that the violation was knowing, then the employer may have to pay triple damages. The law also requires the employer to pay prejudgment interest at the rate of 8% from the date that the wages were due, and if found liable, the employee's reasonable attorney's fees and costs. VOWA also allows employees to bring their cases as class action or collective actions. So I know that was really quick and a lot of information there, but hopefully that will keep everybody on track and at least raises some questions if you don't already know the answers to them. So please make sure that your employees are classified correctly and that you are determining their overtime correctly. And that's all I have. I know that was short and sweet, but I just wanted to get that out there.
Yeah, thanks for that, Tracy. We've got a couple questions here in the queue. I'm going to go ahead and answer Charlene real quick. Charlene asked, will we get a copy of this presentation? And we make every effort to have all of our webinars up by the end of business when we present them. So you'll have the slide deck and the recording of this presentation available at dominionpayroll.com. And generally we're pretty quick, but I don't want to speak for our comms team. So we'll get that up.
Appreciate that. I'm sure they appreciate that.
Yeah. All right, let's jump into some of these questions. Anonymous says, are employers required to track hours for exempt employees?
I don't think so. I think it's only your non-exempt, because with an exempt employee, you're paying them a salary regardless of the amount of time that they work, if it's under or over.
Yeah, I would just say just maybe doing an internal audit, making sure that you are classifying people correctly. But if they're exempt, you don't need to track their hours. Let's see. Anonymous also asks, has Dominion Payroll already set up these earning codes for us reflecting this change?
You know, I don't have a definitive answer on that. I would go with the assumption yes, but you know what? I'm going to check into that and make sure that that has been set up. I don't usually work on the payroll side, but so I am going to have to check on that.
All right. What is longevity pay? Was that in the presentation?
Yeah, it was.
Okay,
so it's,
sorry.
it's just additional wages or other compensation that you give based on the length of service.
Gotcha.
Like if you had a shift differential or something like that.
Gotcha. All right. A couple questions here saying how do we determine if someone is exempt, and was this changed by the Virginia overtime law?
It was not changed by VOWA. It's still the same rules on if someone is exempt or non-exempt. And I just didn't feel comfortable presenting that, because when I started looking into exempt and non-exempt employees, there are some hard and fast rules about like salary and supervision, but there's also some nuances about some different kinds of positions that could also be considered exempt. And I just didn't feel comfortable going into that right now. But I mean, I'm happy to look into that so that we have more of a definitive answer on an exempt and non-exempt. That might have to be
So,
the subject of a different webinar.
yeah, let me jump in a little bit here. I just
Sure.
dropped a link to FLSA it's a very wordy website, but it will give you a definition on how to qualify exempt versus non-exempt. My explanation here is not going to catch every single instance, so please don't take this as a black and white letter of law, but largely exempt employees are, they're always paid salary. They tend to be professional class or executive. They tend to run departments. They have people that report to them. They're doing office non-manual work, and they are making above roughly $35,000 a year. So that's a very rough outline of whether someone is exempt versus non-exempt. I would say go to the FLSA website that I dropped in the chat to really dive into the specifics. And one thing that we see all the time as we deal with clients and their employees is that all of this ends up being fairly personal in that there are so many different ways where you have people with different job titles or job performance requirements and all of these wrinkles that come into it. So it makes it very difficult to give you a one and done answer.
Yeah, and I did see that you can't use job title to determine it. They just said that, you could have a CFO that performs CFO duties, but you title him as a janitor. It doesn't matter. It more about what kind of work that they do and their specific responsibilities and job duties. And there are, not our state so much, but there are state laws that have different criteria for classification. So it just wasn't so black and white. I just was like, I'm not sure I can address that today.
Right. And we are seeing some questions about the salary baseline, and there is a baseline. I'm just trying to make sure I'm getting this number right. It's about 35,000 a year, a little bit more. And just because someone's making above that does not mean that they are necessarily exempt. If they're doing manual labor, if they don't have people that are reporting to them, then they could be non-exempt salaried employees. I would really just, again, and apologies that we're not necessarily the experts on exactly how to parse the language of exempt and non-exempt, but go to that FLSA website and dig into your specific employees. Okay, let's see. So new calculation already set up in our payroll module. We're going to look into that, make sure. Okay.
And I see, as far as I know, the Virginia law does not modify the definitions of exempt. My understanding is that those three things that I had up there earlier, let me just go back to what they were. It's all about really overtime. Whoops, right here. These are the three ways that it can increase your liability. This is where it departs from the FLSA. So I don't really see anything about exempt or non-exempt in that. Oh, someone put in another link too.
I just shared that in the chat so that everybody can see it. And that's the Department of Labor resource there. All right. So let's see. So the Virginia law does not modify the FSLA definition of exempt. No,
that's, yeah. I think it's still, I think it's basically the same as it was before.
Yeah, it's just the calculation of the big change to that calculation of overtime pay. That's really the big Virginia takeaway.
It definitely, and the fact that they are giving employees more time to file claims, but really it's more about figuring out the overtime rate of pay for non-exempt salaried employees. I mean, I'd be happy to dig into the exempt and non-exempt, and we can do that at another time, or I'll just ask Leslie to tack that on to one of her HR things, because that really falls under HR.
Yeah, for sure.
So,
so yeah, I would say to everybody in our audience today, stick with us and look for that email about some future webinars where we could dig in a little bit more on that distinction between exempt and non-exempt, and best practices around qualifying people or categorizing your employees. But the resources that are shared in the chat, that Department of Labor is a good one. The FLSA it's a law firm site, but good advice there. As I said, very wordy, but it does get to the heart of it.
Right. I appreciate you doing that.
Yeah.
Right.
Looks like we don't have any other questions in the Q&A. So I guess I would just say, folks, thanks so much for joining us on this Tuesday morning, about 11:30. So we're going to give you a little time to get your lunch plans in order. But Tracy, thanks so much for the presentation today.
Yep.
I know it's illuminating, and it's always, anxiety inducing when changes around, from the state of the federal government come down. And so thanks for helping us understand it.
And I think what we will do is once I check into whether or not we have it set up in our system, is we'll get marketing to send something out with, other things that we send out. And normally we send out like a newsletter, and sometimes we send out an email blast, and we'll get that put out there.
All right. Wayne says, thank you. This was very helpful. And Wayne, we're happy to be here for you. With that being said, everybody, I hope you have a great afternoon. Keep your eyes on your inbox for future communications about our webinar schedule. And as always, you can go to questions@dominionpayroll.com with any of your questions, whether they are overtime related or ERC or CARES Act or PPP. All of our favorite alphabet soup is still floating around out there. So
that's true. All right, great.
All right, well, y'all take care. Tracy, good to see you.
Yep, you too.
Speak with you.
Yep.
All right, bye, everybody.
See you later. Bye.